All right. We're going to kick it off today with appellate insight into workers' compensation, and we have the great pleasure of having James Donovan, former appellate judge, 5th District, with us, as well as John Larsen, Jr., chairman of the Labor and Industrial Relations Commission. James Donovan is graduated from St. Louis University School of Law. He was a judge in Illinois for a total of 24 years, 14 years as an associate circuit judge and circuit judge in the 20th Judicial Circuit of Illinois, and 10 years in the 5th District Appellate Court. He retired in December of 2012. In addition to hearing cases on the 5th District Appellate Court in Mount Vernon, Illinois, he was assigned to the Illinois Workers' Compensation Division of the Appellate Court. A little less fantastic, but is Mr. Larsen, chairman of the Labor and Industrial Relations Commission. He's sort of the rookie of the two. John was appointed as the public representative and chairman of the Labor and Industrial Relations Commission in June of 2013. Mr. Larsen has graduated at the University of Missouri, and St. Louis University School of Law. He spent 33 years in private practice, primarily representing claimants in his practice, but also served as a special assistant attorney general. Gentlemen.
Thank you. As Pat has so eloquently pointed out, Judge Donovan is by far the senior jurist here, and he's exercised his senior prerogative in insisting that I speak first. We're asked this afternoon to give you some insight into the appellate process. And from my perspective, with regard to Missouri workers' compensation cases in the appellate process, to give you some understanding of what you can do to help yourselves and help us, I think it's important to understand the nature and functions of the Labor and Industrial Relations Commission for the state of Missouri. The Industrial Commission consists of 3 commissioners, 1 secretary, Pam Hoffman, who's been there for over 30 years, 4 lawyers, and we have 6 clerical staff members, one of whom is on loan from the Department of Employment Security. So there's 14 people in our office. Our responsibilities, in addition to hearing every workers' compensation claim appealed in the state of Missouri, includes hearing every unemployment compensation case appealed in the state of Missouri. We're responsible for crafting and signing off on rules and regulations involving unemployment comp, prevailing wage, and work comp matters. We have hearings and prevailing wage cases, and we're obviously also responsible for resolution of many post-trial work comp issues. Arguably, the Industrial Commission is also responsible for administering the Department of Labor, but in a stroke of genius, one of my predecessors delegated those administrative tasks to the director of the Department of Labor, so they're now Ryan McKenna's problem and not ours. I think it's important to understand that the Industrial Commission in Missouri is a creature of statute, and that although we're charged with essentially judicial functions, we are also charged by Constitution, each of the commissioners, with bias. One of the commissioners, Jim Avery, is the employer representative on the commission. One of the commissioners, Curtis Chick, is the employee representative on the commission. I am, in addition to being chairman, which apparently confers no authority whatsoever, but sounds nice, I'm the public representative on the commission. I think the other commissioners' constitutional charges are reasonably straightforward. And it doesn't mean that my fellow commissioners are going to promote bad behavior by the people they're supposed to represent, because they're supposed to represent all employers and all employees. And I think the vast majority of people that participate in the system participate in good faith and with goodwill, And one of our jobs, I think, is to make sure that people that are doing it right are never placed at a competitive disadvantage vis-a-vis people who are trying to scam or abuse the system at some level. Now, having said that, my charge as public representative, I think, is a little bit more ambiguous, and there is no constitutional definition of what that is. What does it mean when I'm supposed to be a representative of the public? And in the 12 months, time flies when you're having fun, nearly 12 months that I've been doing this, I think at this point, at least in the context of workers' compensation, I've come to the conclusion that it's my job to represent the taxpayers of the state of Missouri. Again, in the context of work comp, in my view, the purpose of the work comp law from the outset was to impose on industry the burdens of the costs associated with the industrial process. In other words, injuries which inevitably arise in the course of manufacturing enterprises, in the course of provision of services in the service industry. These costs should be borne by the manufacturing and service industry, so they could be passed along in the cost of the products they manufacture and the services that they provide, and ultimately be borne by the consumers of those goods and services. I think this is, again, a basic principle of the work comp law that's been unchanged throughout its history. And I also think it's a concept that's pretty much universally accepted. The disputes that we've had over the years, of course, revolve around what are work-related injuries. In my view, the legislative changes in 2005 were primarily designed to more sharply define what is truly, reasonably work-related. Generally speaking, in the context of medical issues, what we're trying to do is differentiate between medical problems caused by work injuries or work processes and medical problems that workers bring with them to the workplace, and although they may become manifest at the workplace, really aren't reasonably viewed as work-related. Work comp was not intended to be a lottery system, where just because something happens to you at work, you get a windfall, even though what happened at work was just as likely to happen at home, over the weekend, or the next day. So you understand where I'm coming from. And right or wrong, unless you're behaving badly, you're going to get one vote from the commission. And I would say that the employee representative on the commission, Mr. Chick, who is a former business manager for a union, you can get his vote as well. Appeals to fairness are never wasted. Pointing out bad conduct, bad behavior on the part of claimants, when appropriate, in my judgment, is quite effective with all the commissioners. But for me personally, your strongest argument that you can make is why the costs of medical care, why lost productivity and responsibility for providing for workers' families should be borne by taxpayers as a public welfare system, as opposed to being viewed as work-related costs that should be borne by industries and the consumer of industrial goods and services. If you can convince me of that, I view it as my job to be an advocate for you at the commission and proceeding forward beyond the Industrial Commission through the various courts of appeal. As Judge Donovan will explain to you, and as many of you already know, in Illinois, workers' compensation issues ultimately focus on a special work comp appellate panel. And for anybody who's practiced in Illinois, you will appreciate just what a pleasure it is to write briefs and present oral arguments to judges who understand what you're talking about. And in Missouri, I would respectfully suggest that that focal point is at the Industrial Commission level, and that it's probably at the Industrial Commission level that you have the best chance of having your case decided by a tribunal which, at least in theory, is capable of understanding what you're saying and capable of understanding the practical implications of the issues presented and ramifications of the decisions that the Commission renders. In a nutshell, I would suggest that in Illinois, the Schamel case never would have happened. Past the Industrial Commission in Missouri, your cases are dispersed to the Eastern, Western, and Southern District Courts of Appeal. I know in the Eastern District, at least, those cases are then essentially randomly assigned to 3-judge panels. With all due respect to the members of the appellate judiciary in Missouri, and I don't mean that sarcastically, I would suggest it's almost impossible for them to fully appreciate the practical implications and applications of their decisions. They don't generally have a background in workers' compensation. They're hearing dozens of different types of cases on a daily basis, and quite frankly, I think their job is staggering. Trying to master work comp has been something I've spent 33 years trying to do with limited success. But to try to master corporate contract law and criminal law and every other type of case that appears before them, it's just an almost impossible task. And it forces them, I think, to focus on the case before them and the facts before them. And I believe that at a certain level, that makes it very difficult for them to understand that what they decide in one case is going to potentially have unforeseen and unfortunate implications and applications down the line. Now, we all of us, including at the Industrial Commission level, decide one case at a time. But one of the things we try very, very hard to do is to be very, very careful about what we say and how we decide our cases, and trying to limit the scope of our decisions to the case before us and not be careless with language or broad statements of policy or law that may seem fair and appropriate in the context of a specific fact pattern, but if you think about it, probably is going to have some unintended consequences down the line. And again, Schamel is the poster case for that type of of dilemma. So I would suggest also that the commission would welcome your assistance in presenting not only the facts and arguments applicable to the specific fact pattern in the case presented to us. We will welcome calling to our attention the broader ramifications and implications of the issues presented to us. I think that's always appropriate. Not going to throw somebody under the bus for the greater good, but having said that, helping us to bear in mind that what we do in any case is going to be potentially applied down the line for quite some time. Pointing those issues out to us, I think, is always advantageous. One of my goals is to avoid Shamel-type problems for all sorts of reasons. I want the commission to be an advocate for the workers' compensation system generally. I think first and foremost, it's important that the system be fair. I think it's almost equally important that the system be perceived as being fair. As I said before, fairness arguments win cases. I'm not saying legal technical arguments, particularly in the context of a law that's supposed to be strictly construed. Yes, by all means make them. But fairness arguments, are arguing broader issues. These are of assistance to us, and I think help the commission fulfill its goal, part of which, again, to be fair, to be perceived as fair, I don't think no business or industry that I care to have in this state minds when they pay out money for cases that they deem appropriate. The seriously injured, the legitimate work injuries. I think that there's a problem when they perceive Missouri work comp as a windfall for the marginally injured. And I, at least, am prepared to do what I can to limit that. I think more money should go to people that are seriously injured because I don't think that irritates people. And I want business attracted to the state of Missouri. It's part of being a public rep, encouraging business. This system's fair. It's fundamentally fair. If you come here, you will have no legitimate or very few legitimate gripes. Presenting those issues to us in that manner enables the commission to try to promulgate a coherent, cohesive body of law, particularly as we're still trying to define the changes in 2000 that were enacted in 2005, and hopefully convince the courts of appeal to rely upon us, convince them that they can and should rely upon us, and also hopefully convince the legislature to not monkey with anything for a little while we try to muddle our way through one series of legislative changes at a time. One last note, and I'll turn it over to Judge Donovan. And again, I'm not going through technical do's and don'ts of briefs and, things because I know almost all the lawyers here and they know their stuff, and my one admonition would be trust them and just do what they tell you, and you're generally going to be better off. Of our legal staff of 4 lawyers, 1 does unemployment comp almost exclusively. 1 does primarily work comp, and then we have a couple that do a little bit of everything. This is my homework for this weekend. These are oral arguments for next Wednesday. And obviously the transcripts aren't in here. What I've gotten here are the briefs and the awards. The award of the administrative law judge and all the briefs filed by all parties. One of my legal counsel staff members is going to be reading the transcripts, and I'll be discussing these with him Monday and Tuesday of next week. After oral argument, I'll be discussing with the other commissioners as well. After oral arguments presented, we're all going to get together almost immediately thereafter, and we're probably going to decide most of the cases within 30 minutes after oral arguments have been made. What may surprise you a little bit is that each commissioner doesn't get their own lawyer who just does what the lawyer, what the commissioner tells them to do. The lawyer that writes the case, writes the decision, if there is a dissent, is also going to write the dissent. And we will give some deference to staff legal counsel in terms of how do you think we should go on this? What's your take on it? I always want somebody to bounce I have my own ideas, and I want somebody to bounce them off of. So I'll ask Mr. Talley, what do you think we should do in this case? And he'll tell me, I think you ought to affirm, and I think Jim Avery ought to dissent for the following reasons. So you've got one lawyer who's writing both sides. And I think that may have helped you. Again, fairness arguments make a difference. And even if you're going to lose a case, you can certainly limit the scope of the damage done with policy arguments. Why this is the wrong decision if you're appealing to us. Why is this the wrong decision in this case? Why is this decision at some level unfair? And how and why does this decision have bad ramifications for the future? Those are all 3 important factors, and we see a lot of the first, why this is a bad decision in this case. But in terms of influencing us, getting the decisions you want, and more importantly, getting policies out of the Industrial Commission that you can live with, all 3 of these are factors that I would encourage you in cooperation with your legal counsel to present to us in your briefs and in your oral arguments. And with that, I will turn you over to Judge Donovan, who can explain to you why the Illinois system works better.
I'll try to keep my remarks brief. As indicated, I retired a year and a half ago. When I was on the appellate court, I served approximately 4 years on the Workmen's Compensation Division of the appellate court. I did check with one of the justices that currently sits on the court to try to make sure I was giving you accurate and up-to-date information, and I'll try to do that. The Workers' Compensation Division of the appellate court in the state of Illinois was created by Supreme Court rule in 1984. The purpose behind the Supreme Court's decision to consolidate this into one court was to ensure and promote a uniform body of case law. One judge from each of the 5 appellate districts in Illinois sits on the court. I sat on the 5th District Appellate Court. What that geographically in Illinois is, I sat in Mount Vernon. It included 37 counties, pretty much anything south of Springfield, Illinois. The rest of the state was made up of Cook County, the 2nd, which would be DuPage, 3rd, and the 4th a lot of people would think of as Springfield. So there's 5 of us. To win a case, you have to have 3 in favor of your position. Currently on the court is Justice William Holdridge, is the presiding judge out of the 3rd District. He has been on the court, my guesstimate, over 15 years. Judge Hoffman out of Cook County, over 10 and maybe 15. Judge Hudson, I sat with him. He's been 5, 6 years. Judge Harris is a couple years out of the 4th. Judge Stewart's out of the 5th, 4 or 5 years. The reason I say that is that these judges do acquire an expertise in this field. Judge McCullough, for anybody who appeared in Illinois before the appellate court, he passed away last year, but he sat on the court for over 25 years. He was the presiding judge. He was a taskmaster. He ran the court with a firm hand and made sure that we got our decisions out quickly, and he meant quickly. If we did not get our decisions out within a couple weeks, 3 to 4, he was on the phone calling us to make sure we got it done. And I'm sure Judge Holdridge is the same way. Some statistics that come out of the Commission's online reports indicate that in Illinois, 48,808 cases or claims were filed. The arbitrators heard 3,096. The Commission issued 1,410 decisions. The Circuit Court heard 245 cases. The Appellate Court heard 109. The Supreme Court didn't hear any in 2012. So you could see there's definitely a pyramid effect in the process. The arbitrator in Illinois is the hearings officer. The arbitrator determines the admissibility of evidence, makes findings of facts, conclusions of law, judges credibility of witnesses, determine weight to be given to their testimony. Decisions of the arbitrator are filed with the Commission. Unless an appeal is taken, its decision is final. If you take an appeal from the arbitrator's decision, you would go to the Workmen's Compensation Commission. This used to be called the Industrial Commission, but now is called the Workers' Compensation Commission. The Commission is considered the original finder of fact. So even though the arbitrator has heard and seen the witnesses, the arbitrator's decision, the transcripts, the evidence all go before a 3-person commission, and they make the findings of fact, which is critical based on the standard of review, who makes the finding of fact. The Commission is free to reverse the arbitrator on any legal or factual issue, including determinations of the credibility of witnesses. No additional evidence is heard by the Commission. However, the Commission can remand to the arbitrator for additional evidence. The Commission may adopt all or part of the arbitrator's decision. If no one appeals from the Commission's decision, the decision is final and enforceable. If there is an appeal, it goes to the Circuit Court. Now, the Circuit Court is a trial-level court. I was an associate judge and then a circuit judge on the trial-level court. And trial-level courts are courts of general jurisdiction. But to hear a workman's compensation case, jurisdiction is based on statute, which means you have to specifically comply with those statutes to obtain the jurisdiction of the court. And all lawyers in the room that means timely filing in the Circuit Court, which is critical, or there's no jurisdiction in your case if it will not be heard by the Circuit Court. And to the attorneys in the room also, from being on the appellate court, jurisdiction, of course, is critical to the appellate court. Our first role on the appellate court is to be sure we have jurisdiction. I can remember hearing cases where both lawyers appear in front of us, and first question out of somebody's mouth is, why are you even here? The Circuit Court didn't have jurisdiction to hear your case because the summons was not issued correctly. And that's it. That's as far as the argument goes that day. We tried to kick out those cases before they ever got that far. Sometimes the lawyers kind of wanted it to just keep going so it would be over with. But our job was to make sure we had jurisdiction. In a review before the circuit court, the standards of review are the same which they will be at the circuit court, appellate court, Supreme Court. On questions of law, the standard of review is de novo, meaning the circuit court has the ability to start scratch, make their decision as to what the law should be. With regards to factual questions, though, and this is the most critical part of it, and most appeals are based on factual questions. The standard review is manifest weight of the evidence. Substantial deference is afforded to the commission. Opposite conclusion must be clearly apparent. With regards to evidentiary rulings on motions, things of that nature, an abuse of discretion standard is applied. But the most deferential standard that an appellate court gives to a court below is manifest weight of the evidence. It is difficult to overcome that standard on review. Some people would say impossible, but it's not impossible, but it is difficult. If, of course, the case stops there if the parties are satisfied with the circuit court's decision. But if it is appealed to the 5th District or to the appellate court, then we heard cases in 2 locations, in Cook County, in Chicago, and Springfield. We would hear cases in Chicago approximately 6 times a year, 2 to 3 times a year in Springfield. We heard cases 3 days a week, 20 cases over that period of time. And this is back to the background that if you don't have it when you go in and assigned to this court, you're going to have it by the time you're there for a few years. We read 20 sets of briefs before we go. A lot of the issues are similar. The majority of the appeals are based on factual issues. The standard of review is always the same. So some of these judges have been on there over 10 years. They have written these decisions. So Judge Hoffman, Judge Holdridge, I think have them memorized. Judge Hoffman's written most of them. And if you go in front of that court, when you cite a case, you're citing a case that they most likely wrote, or they were a member of, or they dissented in, and they remember it even better. But that all goes back again to what we talked about in having a consistent area of case law. With regards to, let me check one other thing here. And another thing with regards to the expertise that you get, or hopefully you learn. I had 2 law clerks. Every judge in the appellate court in the state of Illinois has 2 law clerks. Some of them throughout the other districts assign them differently, but my 2 sat in my office. Now that also meant they spent a lot of time on workman's comp too. And over the years, the judge that I replaced had been on the court for 10 years, and I had one of his clerks. So she had a background in workman's comp far beyond that I had. But by the time we were done, she had educated me well, I hope. But that's another point that a lot of people don't think of, is who's reading these transcripts, putting together the draft opinions, are lawyers who have dealt with this for a long time. Let me see. Page 15. One second. With regards to, to the attorneys in the room, with regards to filing briefs in the court, I would ask you, if you will get a reminder from members of the panel to strictly comply with the Supreme Court rules, as they will tell you these are not suggestions. These are rules of the Supreme Court that you are to strictly comply with. When I read a brief, I started always with the appendix, because in the appendix was the arbitrator's, the commission's decision, but many times the arbitrator's decision, and if possible, the critical document in the case. Don't attach a deposition, don't attach a long document, but if there is a document that was critical to the decision in the case, I would definitely consider getting it out front to that judge as soon as possible. Remember, there are 5 of us, but we're spread out across the whole state, and that record is only in one place. And that goes to the judge who is assigned to initially prepare the decision. And that is a judge is assigned randomly by the clerk, who's in the 3rd district now. Used to be in the 4th, but since Judge Holdridge is out of the 3rd, they randomly assign the case out. So they've got the record, we can get it, but if a lot of times a case comes down to maybe a doctor's report. And if it's a short report, everybody will have reviewed it going in. And back to the finding of fact. A lot of times there are disputes over the opinions of doctors. And one doctor says this, and the other doctor says this, and the commission finds that the one doctor's more credible. Well, that's tough to overcome. And you've got to have you have to have good reasons why that case should be reversed when the finder of fact has put the credibility on that doctor. Well, I could go on for a little bit more, but why do that? I think you're really interested in hearing from the commissioner. And I'm going to turn it back over to it.
Well, they showed no sign of that so far, but I think the most telling statement that Judge Donovan made, just echoing for me, is no decisions from the Illinois Supreme Court. That's because the Illinois Supreme Court has come to rely on the level of expertise of this special appellate body, which has, again, you're not going to get, you're still going to get decisions you don't like, but you're not going to get decisions that don't really make sense, or decisions, the ramifications of which become increasingly, apparently, silly with the passage of time. In Missouri, even when we get it right, it takes a long time. Again, you focus at the Industrial Commission level, this pyramid that Judge Donovan talked about. I refer to it as a focal point. But in Missouri, then you're dispersing to 3 different courts of appeal who in the past, particularly memorably in the context of repetitive trauma cases, don't necessarily agree with each other. So then, after you get past the commission, you got 3 different rules of law hanging around for a few years until then you refocus again at the Supreme Court level. I would strongly advocate that Missouri should do what Illinois did and probably pick 1 judge from each appellate district to sit on a work comp panel and come up with a unified body of law that makes sense and that business can reasonably rely upon and know what to expect and know what's expected of them. How much time do we have? Do we think maybe we should start taking questions rather than us guessing what you want to hear?
One other quick thing, I forgot to say how you get to the Supreme Court. And you do not get there by right. They have to take your case, and before you can get there, 2 judges out of the 5 judges on the appellate court have to certify the case as being important enough for the Supreme Court to hear it. But then the Supreme Court still got to take it. So.
Okay, do we have any questions? Spencer, did we get anything text? Did anybody try to text and failed? Oh, we have a question right here.
What is the case you're referring to? The
Schamel?
yeah.
The Schamel case is a Supreme Court decision from the state of Missouri that says that when an injured, a totally disabled worker dies from causes unrelated to their work injury, their dependents, as of the date of injury, are substituted as parties to the case. The most recent case on that is the Spradling decision on the appellate courts of appeal. I think they're right, at least in terms of following Schamel. They say if you got a 6-month-old child at the time of your injury, and 10 years later you die from causes totally unrelated to your work injury, that 6-month-old child is substituted as the claimant, as the employee, becomes the employee in that case, and theoretically can collect benefits for the rest of their life.
Even to when the other guy would have been 130?
Yes. And it could get worse. Because you're focusing on dependency at the time of the accident, I think it's entirely possible that an ex-spouse to whom the injured employee was married at the time of their work injury and who got tired of dealing with their work injury and disability and left them because the courts say you focus on dependency at the time of the accident, not at the time of the employee's injured worker's death, an ex-spouse could collect benefits. Again, it's a decision that marginally can be explained under a very strict analysis of case law. And had it been decided after strict construction was required, you could have at least justified it. But its application, the bottom line is, if you die as a result of problems unrelated to your work injury, your dependents have much greater benefits than if you die as a result of a work injury. And if anybody can explain that from a social standpoint, I'd be very surprised.
Do we have anything else? Any other questions? Anyone? No? Okay. You know, it's amazing how perspective changes. I mean, it was probably a little over a year ago, I was standing at the division talking to John, and I was explaining to him that I thought he was short, he was funny looking, and he'd wasted 33 years trying to understand work comp. Since June of 2013, I think he's grown a little bit. He's a little more handsome than I thought. And
Funnier?
hardly funnier. You're always pretty funny. And maybe a little more bright than I gave him credit for. If you would, please join me in thanking these two gentlemen for taking the time out of their day to speak with us. Okay. At this point in time, we're going to take a little bit of a break. When we come back, CSI Midwest, Claims, Statements, and Investigations, how Missouri, Illinois, and Kansas may be affected. Dave Reynolds will be addressing Illinois, Michelle Simek, Missouri, and David Mosh, Kansas. So come on back to round 2.